Hello, everyone, and welcome. Thank you for joining us today. My name is Annalise Krauthamel. I'm an attorney here at Unruh Turner Burke & Fries in the Trust and Estates and Wealth Preservation Planning Group, and I am joined by Doug Kahn.
Thanks, Annalise. Good to see everybody today.
So we are here today to talk about beneficiary controlled trust planning. How smart planning now protects your legacy and your heirs from divorce, lawsuits, and taxes. So this is a topic that I absolutely love talking about. It is one of my favorite types of planning that we do. But before we dig in, we have to give our little general disclaimer. We would be bad attorneys if we didn't do this. Everything that we are going to talk to you about today is educational, it's informational, it does not speak to your particular situation, it's not legal advice. This doesn't mean that you have retained us to do this work for you. We are here to give you information to make you just better informed about planning opportunities that might be available for your loved ones. So this is not legal advice, it is strictly educational. That being said, let's just dig in. So why are we here? Who's going to benefit from this? What are our goals? So the reason that we are here is because we want to make clients aware of the fact that they have the ability to provide protection to their beneficiaries, their children, their grandchildren, when they leave them an inheritance, that they can create a structure by which creditors, lawsuits that might be facing their children and their grandchildren, tax considerations, divorces, that they are going to be able to transfer their financial legacy to their loved ones and provide them protection from those kinds of things. Doing this kind of planning for our children and our grandchildren and other loved ones provides this benefit, not just for them, but for generations to come. And so that's what we're going to talk about today. That's why we're here, is to make you aware of this opportunity so that you can implement it and provide this fantastic benefit to your heirs. Who will benefit from this presentation? Absolutely anybody that wants to do any of the things that I just described. So if it is important to you to try and protect the financial legacy that you have worked so long and hard to create for your loved ones, if that is important to you, this is for you and you're in the right place. So that is who's going to benefit, and ultimately not just you today, but it's your loved ones. It is the next generation that's going to benefit from you learning about this planning. And what are our goals? So our goals today are to learn about this opportunity that I keep talking about, these beneficiary controlled trusts. We're going to learn about how to create them, how they're funded, how the ongoing administration of those trusts works, and what the benefits to your loved ones really are. Like, how does that operate and how does it create that for your children and grandchildren? So what is the purpose of the beneficiary controlled trust planning? So I think I touched on this a little bit already, but the primary goal and purpose of this kind of trust planning is to protect your family and this financial legacy that you've worked so hard to build. One of the biggest questions that we get from clients when we meet with them is, how can we protect the inheritance that's transferring to our kids? If they're getting divorced, if someone's suing them, if there's a creditor coming after them, what can we do? Are there options? And the answer to that is yes. And we're happy to be able to say that that is the answer. A lot of folks are not aware that this isn't even an option for them. So it's, in this day and age, really difficult talking to friends, to family members, to find someone that has not been affected by these kinds of things, whether it's a divorce, whether somebody's been involved in litigation related to a personal matter, a business matter, had an issue with a creditor that is trying to take individually held assets from them. That is becoming, I think, more and more common. It's something that we see more of and hear more about when we're talking to clients, especially that have kids that are involved in, say, like high liability exposure jobs, doctors, etc. So this is something that affects really just everybody. There isn't anyone that doesn't have that kind of potential risk in their life. And so the purpose of this kind of trust planning that we're going to go through today is to help create a barrier is to help have this financial legacy transfer to your kids and your grandkids with protection from these things. And just kind of diving into some specific examples of these risks, what we're trying to protect against. It is dealing with, and I'll kind of jump down to the bottom of this slide here because this is what we hear the most from clients. Primary concern is, what if my kids get divorced? I'm leaving this inheritance to them, and I want to make sure that their spouse, in the event of a divorce, is not able to access that. Always say we hope that our kids marry somebody that we really like and enjoy. And if they are married, we like and enjoy them. We might even love them. But if they're not married, we probably do not like them quite so much anymore. And we certainly do not want them walking away with a large portion of our children's inheritance. And so that is the motivating factor and driving force behind a lot of clients doing this kind of planning. It is unfortunately, there aren't great statistics. About 1 out of every 2 marriages in this country fails. And so you have this 50-50 chance of there being the potential for a daughter or a son-in-law to, during that divorce proceeding, receive, or I don't want to say receive, in my mind, I have this kind of like visceral response to it. It feels like stealing to me. So stealing part of your kid's inheritance. And so that is one of the huge purposes that we see clients wanting. One of these goals that they want to accomplish is, I want to protect from that sort of situation. There are also other asset protection considerations related to not just divorcing spouses, but litigation, bankruptcy proceedings, all of those sorts of things. There are also this bad personal relationships, not always necessarily a marriage. There can be other personal entanglements that could put an inheritance at risk, and having this kind of trust planning would protect against that as well. One of the things that's really neat about this planning is that when you have adult capable beneficiaries, they can be involved.
Right.
And so that's a big key. And we'll get into that in a lot more detail. We're going to now, Doug's going to talk a little bit about the contrast between, well, what does it look like when you have this kind of trust planning in place, and what does it look like when you don't do this kind of trust planning?
Thanks, Annalise.
Take it away, Doug.
All right. Thank you so much. Great introduction. I think really to set the tone, to get a little bit more in depth with this topic, it's important to recognize what the planning looks like in circumstances where we have not created any kind of asset protection for the beneficiaries. And it really is that more traditional landscape on the planning side. So during lifetime, if you're deciding to make gifts to your children or loved ones, you would simply write that check and give it to them outright, and write that to them. They deposit it into their personal account and go about life's business from there. Similarly, if you're doing will planning for your adult beneficiaries, you're naming them as the recipients at the time you pass away, and the distribution would go through your will or revocable trust directly to them and into their personal bank accounts, and potentially into joint accounts with their spouse. If that's the case, either during a lifetime, if you're making gifts, or if you're giving assets directly to your children or loved ones through wills or a revocable trust, those assets they receive from you will be 100% vulnerable to divorce, creditors, and lawsuits. So obviously that's scary. We don't really think of it that way when we're making these gifts during lifetime or at the time we pass away, but that's the truth. Assets that you're giving directly to individuals become vulnerable to them and to the things that are happening in their personal lives. Even in situations where we have young beneficiaries and we're taking care of the protective period while they're younger, making sure that someone is appointed as a trustee of a minor's trust, that protection only continues until the trust comes to an end. And the ending of that trust might be over a period of years or a period of years with multiple distributions, but it usually has an end date, and a date which the trust will conclude. And that may be, again, a point in time when your child reaches an appointed age. And once they hit that age, the trust will typically say, now the outright distribution will take place. The trustee is supposed to write that proverbial check to them and close the trust. And the beneficiary takes that check and deposits the money or assets into their personal account or into the joint account with their spouse. And once they do that, it's 100% vulnerable to all the risks that they have in their personal life: divorce, creditors, lawsuits. So we have opportunities to create protection for them, but it's up to you as you're doing the planning to take advantage of those opportunities and provide an enhanced inheritance to the beneficiaries. And so I'm going to contrast the more traditional way, which I just described, with opportunities that you have using the beneficiary controlled trust. So as I've alluded to, this beneficiary controlled trust planning can be incorporated to hold gifts during lifetime, or at the time you pass away, we can write these trusts into your will or your revocable trust so that they are funded with the inheritance that you're passing along to your beneficiaries at the time you pass away. So in either case, we establish these trusts and they become irrevocable at the time that they're funded. Most commonly, we'll establish those trusts with the family trustee or beneficiary acting as trustee of their own trust, assuming that they are adult, capable beneficiaries. Okay, the idea behind these trusts is for them to hold the inheritance or the gifted assets, and for the adult, capable beneficiary to manage those trusts and the assets that are in them for the balance of their lifetime. So there will be no end date. You will read these trusts and you'll never see that when your child or beneficiary reaches a certain age, the trust comes to a screeching halt and ends, because that's not what we want. We want the trust to continue for the balance of their lifetime. So what we're striving to do is give them the powers and the abilities to manage the assets underneath of the trust in the best way possible, so they're investing the assets and also having the ability to make distributions out of the trust for the most common reasons. So you'll see for our situations that we're drafting for individuals that we would typically expect could handle assets for themselves, but we want to maintain the protection for them. We'll give them significant control and power. So first of all, the child is going to act as the trustee of their own trust, and then they'll be given the power to distribute for health, education, maintenance, and support. We frequently refer to this as HEMS, which is also referred to as an ascertainable standard. And so I'm hard pressed really to come up with, and I'm often asked this, like, what doesn't fit under health, education, maintenance, and support? Well, most things do. And that's really the point. We're giving the child as beneficiary trustee the ability to make distributions for health, education, maintenance, and support. Those are likely sufficient reasons for making distributions. And in fact, our goal in a lot of cases is really never to make distributions from the trust. We're expecting our children and beneficiaries probably to have, fairly strong financial lives of their own. And if that's the case, they may have sufficient assets to pay their everyday expenses from the money that they're earning themselves in their own work and jobs and personal life. And the trust in those situations may just be a resource for investing and managing the assets, and they may never even want or need to take distributions from the trust. But the comforting thing is, if they need the money and they have to pay for something in their personal lives, they, as the family trustee or the beneficiary trustee, will have the power to distribute for these very broad reasons of health, education, maintenance, and support. So I can't stress that enough. We have clients who ask this and worry about it all the time. Well, they ask, is this going to make it hard on my child when they want or need the money? The answer to that is no. We build these trusts specifically with the idea of getting the kids as close to the legal ownership of the assets without crossing the line. So we're trying our best to provide the best of both worlds, where they can use and enjoy the assets in the trust. They can invest the assets and get distributions if they need them. But if they do have one of these things happen in their personal lives, which we're hoping will not happen, but if they do have the divorce, the creditor, or the lawsuit, the assets inside of the trust will be insulated from those things. And a big part of that is that we do not give the beneficiaries as trustee the ability to make unlimited discretionary distributions for any purpose. That is not because we're trying to keep the assets from your children or beneficiaries. The purpose of limiting their ability to take distributions on their own to this HEMS, or health, education, maintenance, and support, is that if we gave your child or the child trustee the ability to withdraw for any purpose, and if they then confronted the divorce, the creditor, or the lawsuit in their personal life, the argument from the other side would be that the assets in the trust are so available to them and that they have so much power and authority to withdraw that the assets in the trust should be treated as though they are theirs for purposes of paying this creditor, divorcing spouse, or someone who's suing the beneficiary. So we need to place a limitation, and the limitation is there for their protection. And it's really what makes the wall around the assets as thick as possible, with the thickness level that we need, so that if they confront one of these things in their personal lives, we can know that the assets inside of the trust are protected. But as I was mentioning, are the kids really going to need to take distributions above and beyond health, education, maintenance, and support anyway? Very rarely, and I've been doing this for 30 years, very rarely have I ever had a trustee beneficiary who has wanted or needed to take money and assets out of the trust above and beyond the HEMS standard. If they need to, all that they will have to do is appoint a person who is called a disinterested trustee. And that disinterested trustee is given the power in the document to authorize distributions for amounts in excess of HEMS, and again, for any purpose. So think about it. If they got to that point and they wanted or needed the money, they can appoint the trustee, and then that trustee, whom they have appointed, will only have to sign off to say, yes, it's okay to take more. So it's not as big of a limitation as you might initially worry or think, because we are giving them the ability to name the person. And frankly, we're hoping that that person's just going to go along with the program and sign off when your child wants or needs distributions in excess of HEMS.
Might sound a little abstract right now, like this trustee. We'll talk a little bit more and in more detail about the trustee specifically,
Yeah,
as we go through here.
So just kind of moving along a little bit on the structure and creation and funding of the trust, just mechanically speaking, because as Annalise alluded to, we're speaking a little bit in the abstracts, and this, like in the concrete scenario where we have a client who has created the trust planning in their will or in their revocable trust. This new trust for their child or beneficiary will literally be written into that document, and it will spring into effect at the time that they have passed away.
May I interject just really, really quickly? That this is a huge misconception that I sometimes see from clients. They think that they can't have trust planning for their kids unless they have a revocable trust. And so that's just something that I wanted to dispel that myth. You can have trust planning for your beneficiaries under a will as well. Sorry to interrupt.
Sure, no problem. Yes, these trusts are written into these documents, either the will or the revocable trust, whichever planning document you're selecting for your purposes, this trust planning can be written in there. And by the way, you can continue to modify that trust planning during the balance of your lifetime, because if you're funding it at death, it only gets created formally and legally at the time you die. So you could update your will, and by updating your will, you could modify the terms of the trust planning underneath of that will. Same thing would be the case underneath of the revocable living trust, if that's the document that you're using, maybe for probate avoidance purposes. Okay, so it's important to know it only comes into effect legally at the time that you've passed away. You can also create that trust during lifetime. So that would be an irrevocable trust. And that's utilized in situations where we have clients who want to make very large gifts to their child or children or beneficiaries now. And they say, I want to give $1 million to each of my kids. Obviously, these are clients who have the financial wherewithal to do that. But when they're making these larger gifts, we say to them, well, look, hold on, before you make that big gift, why don't you consider making the gift into a beneficiary controlled trust? And that would be an active trust once the money or assets go in, and then the child beneficiary trustee would take over, and then they would manage that gift inside of the trust, and therefore the assets would be protected on a go-forward basis from divorce creditors and lawsuits. So we do want you to know that if you're thinking about gifting, using this trust planning during lifetime is a real advantage for the kids. And then the way the documents typically are drafted would be to say that when you were to pass away, the remaining assets in your estate would pour into that same trust that you had created while you were alive. And then all of the assets, the gifted assets and the assets that are being inherited at death, would congregate underneath of that single trust and be managed there efficiently by the child beneficiary trustee who is handling the assets inside of that trust. So great opportunities either through gifting or at the time you pass away to fund these trusts. It's important to note that where you have multiple beneficiaries, there will be separate trusts, one for each of them. So I want everybody to know that when you're doing this planning, each child will take their share of the inheritance and they'll go their separate ways, and they'll make their separate decisions, investment decisions, distribution decisions. Each one can make the plan work the way they want it to for their situation. They're not stuck, worried about what their brother or sister or siblings want to do under certain circumstances. They'll make the decisions for their share of the inheritance underneath of the trust. Each trust is going to have its own separate EIN number, which is like a social security number or business tax identifier assigned to it. That gets applied for through the IRS at the time the trust is funded. So either during lifetime if it's gifting, or at the time you've passed away if it's being funded with assets at that point. But it's not assigned at the time that you actually write the trust, only once it's funded. Okay. So if you kind of look at this structure and the creation of the trust at death, you pretty much see this flow chart, which is the descendant's estate would be administered. So client has passed away, they have assets in their name, there's going to be an executor of their estate. The executor is going to be responsible for all the typical responsibilities, paying the bills, expenses, taxes, collecting the assets, selling real estate potentially, and then congregating those assets. And then when they're done with that, they split the assets that are in the estate pot into shares, one for each of the beneficiaries. And then when the assets are distributed, they'll go into the separate trust accounts that have been established by each of the beneficiaries at their selected financial institution. So remember, each of these trusts will have its own tax identification number. The trustee of each trust, meaning each child potentially, would take that trust, open up their own account with their own tax ID number, and then the executor of the estate would fund each of those trusts with the fractional share of the estate that's being distributed to them. And then that trustee takes over the responsibility of managing the investments of the assets underneath of that trust on a go-forward basis and independent of their siblings or independent of the other beneficiaries. And they're doing that based on the powers and authorities that are granted to them underneath of the trust provisions, which, by the way, are extremely broad in the documents that we're preparing, because we want the beneficiaries to have the flexibility to do the things they want to do with the money without having to take the assets out of the trust. So our goal really is for them to use and enjoy the assets underneath of that trust, just like they would have in their personal name. But by virtue of those assets being owned by the trust as an entity and not in their personal assets, in their personal name, those assets will be protected in case they run into one of these issues that we've been talking about, the divorce, the creditor, and the lawsuit. So great planning opportunity for them. And the idea is to build the wall of protection around these assets for the beneficiaries. But, we know that there are things that can come up during the beneficiary's lifetime. And if that issue comes up in their personal lives where they need the money, we just want to discuss a little bit about the distribution standards and just specify for you how that would work for them. So you can see that we can make these distribution standards very broad, or we can be restrictive if that's what you want. So we're talking about really the planning in the way that would make it most user-friendly and easy to access by the beneficiary. So this structure that we're talking about mostly is for the adult capable beneficiary who you would otherwise just say, you know what, they're great at investing, managing money, we trust them to spend it the right way. So we're not protecting the money or assets from them. We're protecting against the third parties that might come knocking, asking for the money at a later date.
I have to share while you're talking about this protection from third parties. I had a client once that described this trust planning. I explained it to them and they said to me, well, is this a good illustration? It's kind of like it's creating a force field around the inheritance. And you're saying wall, they said force field. And I thought, yes, that's exactly what it is. I love that illustration. I use it now all the time when I'm talking to clients. So
yes. So if there are any Star Wars or Star Trek enthusiasts out there, you can now picture whatever your spaceship, the inheritance spaceship, is being surrounded by a force field.
When we're talking about the distribution standards, I always sort of describe it like you can make that force field sort of like stronger or weaker depending on how you structure things. So
I feel like I should have a lightsaber. All right. Back to the scheduled programming. We can veer off pretty quickly, so we have to rein ourselves back in.
Estate planning is fun.
Yes, lots of fun. Lots of force fields and lightsabers, all kinds of fun stuff. So we're building this force field around the inheritance, and still the beneficiary, in most cases, will be given the ability to access the funds that are in the trust liberally. However, for those out there who are thinking that there might be a beneficiary in your world that might not be great at handling the assets for themselves, and that maybe they could use the guidance of a different trustee or another trustee who's helping them along the way, I just want everybody to know we can structure the trust to be more restrictive and also put someone else involved as the only trustee or as a co-trustee with your beneficiary, depending on the situation. So as much as anything, just keep in mind your situation might be different than we're describing here. and we can tailor the documents in whatever way is necessary. And it's also worth mentioning that you might have two people in your family as beneficiaries who are really good for the more liberal trust planning, and you might have a third beneficiary who needs some more hand-holding. And then we can draft the planning differently for all three of those beneficiaries, depending on this particular situation. So even though in this program we're talking with generalization, we want you to know that there's a lot of adaptability and tailoring that can be done to make the document work the way you want it to work. Okay. So I'm going to pass it along here to Annalise to take over some discussion about the trustee role and the responsibilities of the different trustees that are involved in the documents.
Thank you, Doug.
You're welcome.
I promise I won't talk about lightsabers anymore. So we keep talking about, the trustee can this, the trustee can that. Maybe a step back, it could be helpful, which is like, what is a trustee? What are they doing? Who are they? So a trustee is either a person, an entity that is managing trust assets, that's following the terms that are set out in the trust. And that's what Doug was just talking about. These trusts can be drafted in a number of different ways. And those terms are kind of like the rule book. And you get to set those terms and you get to say, this is how I want things to be structured. I do have this one beneficiary who needs a little bit more hand holding. And so maybe things are a little bit different for them than for the others. But those terms that are set out in the trust, it's the trustee's job to make sure that those rules are followed. You can have just an individual person. It can be multiple people. It can be what we would think of as a corporate trustee, bank, trust company. It can be some combination of an individual and a corporate trustee. All trustees are fiduciaries, meaning that they have this duty to act in the best interest of the beneficiaries, both current and future. And so they're not able to sort of self-deal, make distributions to themselves to go on vacation. Their job is to make sure that everything is managed in a way that is giving all of the benefit to your children, your grandchildren, whomever the beneficiaries are. Trustees have lots of responsibilities. Like I said, they have to follow the rules, carry out the provisions as they are drafted in the trust. They do have to act in the best interest of beneficiaries. The trustee is in charge of managing the trust assets, deciding what is the investment strategy, keeping good records related to that trust administration. So what's coming in, what's going out, transactions that are occurring. And also, Doug mentioned there's going to be this EIN number. That means there's going to be a tax return for the trust. And so the trustee is in charge of making sure, working with accountants, making sure that those tax returns are prepared and filed as needed. We'll talk about income taxation in a little bit more detail as we get further into our presentation today. Doug mentioned you have this interested trustee, you have a disinterested trustee. We're going to speak in general terms. Generally, the interested trustee is going to be when we have an adult capable beneficiary. It's your child, it's your grandchild, whoever that adult capable beneficiary is, they're the interested trustee. They're interested because the trust benefits them. And so they, in that context where they're capable of managing finances, we trust their decision-making ability. We want them to have absolutely as much control, access, and authority as possible while still providing them with that level of asset protection, that force field. When that's the situation, the interested trustee is granted tons of authority. They're really able to do everything. They're the boss, they're in charge. And I shouldn't say everything, just about everything. We're as close to the line of everything as we can possibly be while still providing them really great asset protection. We keep saying this, but it's worth repeating, like the goal of this trust planning is not to keep your kids, your grandchildren away from their inheritance, to keep them from enjoying it. We want them to be able to use and enjoy it. We don't want interloping third parties to be able to get behind that force field and take it from them. That is the goal of this planning. So this interested trustee, when it's your child, they're deciding, how do I want to invest? What do I want to invest in? We'll talk a little bit more about investment management in detail as we move on, but they have this broad authority. It's up to them. What are they investing in? Business, real estate, securities, etc. Their call. They're the boss, they're in charge. we will give them also the opportunity to be the person who is in charge of appointing a disinterested trustee should a disinterested trustee be necessary. And we'll talk a little bit about what that disinterested trustee is and what they do here after we finish talking about the interested trustee. But your child is in charge, they're this interested trustee. When we're thinking about young beneficiaries, if we have a minor beneficiary, of course, they're not going to be in charge of things. They're 14 years old, no matter how responsible and mature they might be. Not for them. And so we want, in that kind of a context, we would have an interested trustee potentially that's a family member. And so the family trustee, when somebody is young, would in many respects be an interested trustee as well. And then at a certain point, that transitions. Once children are old enough to be their own trustee, they would be the interested trustee. And that's up to you to decide what is that age. And that looks different for everybody. To Doug's point, we have separate trusts for each of your children. It is always fascinating to me just observing the different personality types that come out of the exact same household, same parents, same environment, same everything. And you may have one child is like incredibly financially savvy and one that is lovely and we adore them, but they're probably never going to be great at managing finances. And so the terms and the way we're drafting for those situations can be different. That interested trustee in a circumstance where you have a beneficiary who's maybe not as great at doing those things, maybe they become an interested trustee, but they work with somebody else and they have that hand holding and they have a disinterested trustee that is involved and has them sort of have a seat at the table, but is not ultimately the final and only decision maker. They're not unilaterally sort of managing things. The disinterested trustee component is really important. It really increases the level of that force field, that asset protection, that wall. Having the disinterested trustee involved, we have a code section referenced here from the IRS code, which may not be interesting to you, but it's very interesting to us. So there's this section of the IRS code.
Maybe to you. Not super interesting to me. But,
So this section 672 defines like what is a related or subordinate party. And so a disinterested party is somebody who is not related or subordinate.
ooh, that's so interesting.
See, I told you.
Yeah.
Are you convinced?
Yes.
So a related or subordinate party is somebody that's related to the beneficiary or subordinate to them. So when we're thinking about that, it's you wouldn't have somebody, they couldn't be a disinterested trustee if they're your spouse, if they work for you, anybody that you exercise control or authority over. Those folks cannot be disinterested trustees. Disinterested trustees are maybe just a family friend. That person is not related to you. They're not subordinate to you. Maybe an advisor of some sort. We sometimes see people choosing accountants, things like that. Corporate trustees, of course, are disinterested. Banks or trust companies. So that's a disinterested trustee. And the involvement of the disinterested trustee is going to depend on how the trust is drafted, but in a context where we have adult capable beneficiary, they're making distributions to themselves for all of these things: health, education, maintenance or support, HEMS. We do love our acronyms. We have BCTs, beneficiary controlled trust. We have HEMS, health, education, maintenance or support. And so when they're making these distributions to themselves for HEMS, they're not involving that disinterested party. The disinterested trustee is only getting involved when there is a distribution for something beyond HEMS, or if there is a reason that we might want to increase the strength of that force field, maybe the disinterested trustee gets involved for HEMS. If we have a child that has a really high liability exposure in their personal life, we might want to increase the strength of that force field a little bit and say, yeah, you know what, we're going to require this disinterested trustee even if we're making distribution for HEMS, but we're still going to give our children the power to appoint that person, fire them, and it still has them in the driver's seat. That's not to get too far down into the weeds, but just to make the point that you really can tailor this specifically to each individual family beneficiary and make sure that it's accomplishing your particular goals. But in a kind of traditional circumstance, this disinterested trustee gets involved when there's these discretionary distributions beyond HEMS. and what that looks like kind of logistically for your child acting as the interested trustee. It's not this formal, really involved process. If they want to have the disinterested trustee, if you do rather want to have them involved in these distributions, your child generally will appoint whom that person is, might just be a family friend, a CPA. They email them and they say, hey, I'm taking this distribution out of the trust. I need your sign off on that. That person writes back. So sure, have at it. Like that's what the terms of the trust say. Yes, I'm on board. That's it. They don't have to take that, file it anywhere, submit it to anyone. It just stays on record with their trust document. And now, if it's, 10, 15, 20 years in the future, they're getting sued, they're getting divorced, there's a creditor coming after them. They have this paper trail. And this trust planning, if somebody is saying to them, divorcing them, suing them, and they say, well, wait a minute, you're the beneficiary of this trust. You're also the trustee. You really have this broad access. How is this any different than you owning these assets individually in your name? They get to say, totally different. One, I never took possession of these assets. They went into this trust. Look, there's this ascertainable standard that I have. It's health, education, maintenance, or support. It's these specific things. And for these other distributions, I have this disinterested party that I would have to get involved. That is completely different than me owning these assets individually in my name. So it creates, in a practical sense, still access completely to the use and enjoyment of the inheritance, but on paper it creates this separation that creates that force field that makes it really difficult for this outside force to be able to try and get in there and steal their inheritance. So that's sort of how that interested and disinterested trustee relationship works. And it will be up to you and tailored to your goals to decide like exactly the duties that each of them have. But it's usually interested trustee, really in charge of the day-to-day, absolutely everything. The disinterested trustee involvement is limited in most cases because we don't want to make it more difficult to allow your kids to access their inheritance. That is not the purpose of this planning. There is also what we call a trust protector. So a trust protector is very different than a trustee. The trust protector, as the name implies, is really there to protect the trust. I always have this mental image of like somebody in a cape flying, like, I'm here to protect the trust. So the trust protector is
But
not a
can they fly through this force field?
The trust protector, ooh, that's a good question.
With the cape, maybe, I would think.
Maybe. I think the answer is like sort of yes.
Yeah. One of the trust protector powers is the ability to fly through the force field.
Only if you have your lightsaber.
Okay.
And cape, of course. So the trust protector is there to do all sorts of things. The trust protector is granted tons of powers, and the trust protector can do all of the things that your kids would be able to do during the administration of their trust by going to court, but we want to keep them out of court. That's really ultimately the goal of the trust protector, is to make the administration of the trust for your kids and beneficiaries as simple and as easy as possible. And that means staying out of court. And so if there is, for example, a trustee vacancy, so if you have young beneficiaries, you've appointed multiple people to be trustees, but there has been a terrible common accident, they're all not here anymore. If that were to occur, there would be a trustee vacancy. The trust protector would not step in to become trustee, but they have the power to appoint someone to be trustee, and that keeps your kids out of court. It means they don't have to pay lawyers to go stand in front of judges to appoint trustees. The trust protector can do that. Trust protector can modify the terms of a trust if it's necessary. So these trusts can last forever. That's one of the phenomenal benefits of them, is that they provide this like multi-generational protection for your family. So when we draft the trusts, they sometimes are fairly lengthy. It's not something that clients always appreciate, but we are trying to imagine what is every hypothetical scenario that could be encountered in the future during the administration of these trusts. But because they can last forever, there might be a circumstance 100 years from now that just wasn't foreseeable. There was a change in the law. And so if that were to happen, the trust protector is typically granted the authority to modify the terms of a trust to respond to a change in the law. Maybe the trust needs to be moved. Maybe if you're a Pennsylvania resident, you pass away, this trust is funded, or it's funded during your lifetime, that's a Pennsylvania trust. But maybe your kids live somewhere else that has trust law that's more attractive in some way, or there is some reason why it would be beneficial for them to have the trust located somewhere else. That's the trust situs where it lives. The trust protector will have the power to move the trust situs, to move that trust to another state if it makes sense, if it's advantageous for your children. If there's any kind of conflict between trustees, beneficiaries, something that needs to be sort of mediated, the trust protector will have the power to do that. It will be entirely up to you who the trust protector is. It can be an individual. Tons of clients appoint the law firm to do that job. I think the sort of thought process there is, even if I appoint this person, they're going to have to retain you anyway to do that. So we are frequently appointed to be trust protector. And it's a really great tool, and it really does make everybody's life much better in the future if these things have to occur. Yeah, go ahead.
About the trust protector, just to mention, I think it's important because we do get this question frequently about the job of trust protector. It is what we call a non-fiduciary role. So to contrast it with the trustee, the trust protector does not have any everyday involvement or need to watch over the actions of the trustees or of the trust. So the good news is there, you appoint a trust protector, they're listed in the trust document, and they're more or less there to be called upon when needed by the beneficiary or by the trustee for changes in the law, changes in the personal life of the beneficiary, or some other common needs like a vacancy, which could occur either because the trustee has passed away, or you do on occasion have a trustee who resigns, and they could resign because they're older, become incapacitated, they're in an accident, or maybe they just don't want to do it anymore. And so the trust protector can step in and work with the family to appoint a successor. But
rogue trustee
could be fired by a trust protector. But I'd say the non-fiduciary piece of it also makes a difference from like a fee perspective, because people are naturally questioning like what kind of fees associated with that job might be charged. And the answer to that is it's really only when the trust protector has to do something and is called upon by the beneficiary or trustee will the trust protector ever even consider charging for their time associated with working. Because it's non-fiduciary means that the trust protector doesn't have to check in, watch over, be involved. So they're not charging a regular fee like annually or monthly or quarterly or anything like that. It's just when they're called upon to act.
That's a very, very good point. I have had a client say, well, wait a minute, are we appointing you? And now you're talking about compensating yourself. No, only if we have to do something. It's not a racket of any sort.
Yep.
Next up, Doug, investment opportunities. You're going to talk a little bit about that. So investing inside of these trusts, what that looks like.
Yes. So, I mean, we've talked about the funding of the trust and where the assets are coming from. And now it's important. And we've also even talked about distributing the assets to the beneficiaries and how easy that can be. But with our overarching goal of maintaining the trust for the long term and not depleting it and more or less using it as an investment vehicle, it's important to talk about what the assets in the trust can be invested in. And the answer to that is pretty much anything that you could invest in yourself. You can invest in as the trustee of your own trust. So imagine you've received this inheritance in your trust, and now you've deposited it into the proverbial trust account, and you're deciding, what do I want to invest in? Well, your investment array is extremely broad, and you can invest those assets in cash, stocks, bonds, mutual funds, real estate, business interests. You could buy Bitcoin. You could start your own business and own the shares of that business in your own trust and hold it there, so that if you did ultimately have the personal lawsuit or creditor or divorce, your business shares or the stock shares are protected from those kinds of things. So you'll see these documents, and Annalise mentioned that they're fairly lengthy. I mean, they no longer really appear lengthy to me because I'm so used to seeing them, but I know to individuals who, don't see these documents frequently will comment, why are these documents so long? It's not because we're charging by the pound, which is a joke that more than one client has said. So if you were thinking it, I've already heard that one.
Nor with the word, so heard that one.
Yeah. It's because we want to arm your beneficiaries with the power to make these decisions in the most flexible way possible. So we give them these sections of the document which are dedicated to the different investment opportunities. There's going to be a section that gives them the authority to invest in stocks, one for bonds, mutual funds, real estate, business interests. So the document is dedicated to giving them the power and authority to do that. And there's even a section in most documents that gives them the ability to opt out of something that's called the prudent investor rule, which sounds crazy. Why would we want our trustee to invest in some way other than the way a prudent investor would invest? But the answer to that is the legislature in Pennsylvania developed a definition for what a prudent investor is. And that prudent investor may not really look like our beneficiaries model. So our beneficiary might be heavily weighted in real estate, or they may be heavily weighted in some sort of business interest, or they may want to be super conservative and put everything in a money market account and draw 4.5% a year, and they're good with that. They are given the power by the document to invest in whatever way and in whatever structure they want. So they can buy any of these kinds of different investments, and they can also be more or less heavily weighted in any one of them, depending on their particular goals and intentions at that particular point in time. Okay, so the investment structure is one of my favorite things because I enjoy that in my personal life, like the ability to take my money and invest it and do what I want with it. So I really think about it a lot as I'm preparing these documents for clients and for their beneficiaries, because I think about, well, what might a child as a beneficiary what might they want to invest in? So I'm always thinking about those kinds of things. And then unfortunately making the documents longer so that clients can complain to me about how long the document is. But that's really why. So when you see these in draft and you think to yourself, oh, these are kind of lengthy documents, now you'll know the answer as to why they are. And you'll be thankful that these extra powers are there for the kids, because we want them to be empowered. Also, beyond the investment management, a really kind of a neat component of the structure of the trust is the ability for a beneficiary trustee to lend themselves money from the trust. Initially clients are like, why would somebody want to lend money from the trust? Well, the reality is that it's a great way for the beneficiary trustee to get the liquidity from the trust to use in their personal life without losing the asset protection for the money that's being lent out from the trust. So it would be contrasted with taking a direct distribution out of the trust to buy something in the personal life of the beneficiary. So, this is a great example, and probably the most common scenario where lending makes sense. You'll see here, and we have this happen all the time, where we have clients who have passed away. They create these trusts for their beneficiaries, and then their beneficiaries are working with us to, understand more fully how the trust works. And they ask us, well, you know what, I'm thinking of buying a house with my spouse. And that house is $1 million. I'd like to take $1 million out of my trust, and I'm going to buy the house with my spouse and put it in our joint names. And then I say, well, wait a second, before you do that, just recognize that once you take that $1 million out of the trust and you buy the house and you put it in the joint names with your spouse, it's a marital asset. And if you ever did have a divorce and that house is sold, it would be a part of the divorce division at that point completely. Okay, so there would be no longer would there be any asset protection that we've been trying so hard to provide. So instead, how about this for a solution? You, as the trustee of your own trust, can lend you and your spouse $1 million. You can go and buy that house. You own it together. You enjoy it together. You live your lives. But at the same time, we record a mortgage against the property. And the mortgage, just like a bank mortgage would say that you and your spouse owe $1 million back to the trust. You don't necessarily have to charge an interest rate. You could just have $1 million lien against the property, but you'd be in first position. So even if you had a second loan, that $1 million lien would be in first position. And the importance of this is if years later something happens and you end up divorcing, and that property is sold, the $1 million loan gets paid back first. And then, to the extent that there is any gain above and beyond the $1 million, that would be marital and would be divided in accordance with any kind of marital division. But the $1 million that you had put in from the trust would be returned to the trust for you as the beneficiary trustee to use alone and would not become a part of the divorce division. So it's great planning because you got to do all the things you wanted. You got to buy the house, you got to use it, you got to own it with your spouse, but you also preserve the asset protection and you got to have that $1 million under that worst case scenario coming to fruition. And if it never happened and you never divorced, there's no negative whatsoever. It just sits there as a placeholder to maintain that protection. You could also forgive the lien or you just leave it and it would technically be paid back to that trust. And there may be some tax reasons why that might be advantageous down the road as compared to just forgiving the debt at that point. So great opportunity to maintain the protection and be able to have access and use of the liquidity during that period of time.
I think I love talking to clients about it. I do sometimes have clients say, oh my gosh, Annalise, like, how are my kids going to know this, right? So I always, during the course of an estate administration, you pass away, you've created this planning for your children, we explain this to them. We explain to them how it works. And I always say, I don't necessarily expect that your kids are going to remember every single word of technical language that is in the document, but I drive home to them, listen, you have this really broad distribution power. If you are thinking of making a large distribution to yourself, just pause and think, okay, I have to call Annalise, I have to call Doug, and just call us, and then we'll talk about this and say, yes, you have this broad distribution power, but there's this really neat way that you can maintain that asset protection in this situation. So that's always something I talk about with clients.
Yeah, that's a great point. And just before we move on, a couple of points there. I mean, we have a lot of clients who do this planning. I mean, I'd say an overwhelming majority of our clients who do this planning. And a lot of those clients who are doing the planning will have a family meeting with us and with their children or beneficiaries to explain what to expect in the future so that they're forearmed with the concept. And as much as anything, what I've found over the years is that those family meetings will put the children at ease so that when mom and dad pass away, they can remember and recognize what the plan and the intention was, and they're not taken by surprise. And they can more easily adapt to the concept of the assets going in trust as compared to going to them as individuals. And I'd say frequently we'll have clients who are beneficiaries leap to the conclusion that mom and dad didn't trust them. Yeah. And that's why the trust is in place. That's, of course, not true. The intention is to enhance the inheritance. But if you tell your kids or have that meeting with us so that we can tell the kids together with you, they can remember that when the time comes, and they can say, oh yeah, mom and dad did this trust planning, so I won't lose the inheritance. Like, I'll have clients who have had that meeting, and then they'll come in as the executor of the estate or the beneficiary of one of these trusts, and then they will parrot back to me the exact words that we said at that meeting. I'm like, wow, I can't believe they remember exactly what they said. But it's amazing that beneficiaries really do listen. And when they hear those things, and I think it's nice too, because I think that when you tell them yourself, it means more, rather than just seeing a cold document after you've passed away. I mean, if you could tell them and explain to them, like, this is why I'm doing it, and this is what I want for you. And it would be, kind of a warm moment talking about a really, sad, cold time in the future, but it gives you an opportunity to really let them know that you're thinking about this in advance, you're planning, and the advantages that you're providing to them. And when you tell them about the advantages and the opportunities, it'll be more well received in the future. So I do encourage people to have that kind of discussion, either alone as a family, or we welcome to have those family meetings, because we really find them to be very valuable when the time comes.
We have some really good materials about this kind of planning, like educational materials, reports and such, that we'll definitely send to you after this presentation, and that also you can make available to your kids, and it gives them a understanding of the planning. They don't have that initial suspicion. I do love the family meetings too. From our perspective, it's really nice to get to meet the next generation, and then when we all talk and we all get to know each other, when the time does come, your kids know that we knew with their parents and knew what they wanted, and we had that relationship. So there's a lot of value to those family meetings.
And if you ever want to, you can have us share this program with them, so we could also pass this along to them. That could be helpful. And yeah,
absolutely. Now I'm glad you brought that up. Family meetings are one of my favorite things.
They're fun.
They really are. All right, so you are going to talk next, Doug, about making distributions during the beneficiary's lifetime. We've touched on this, I think, sort of incrementally as we've gone through.
Yeah. I mean, I don't want to belabor this point, because I really think we have been thorough with the concept of distributions. We want you just to remember that the assets are inside of the trust are protected, and that we've built this force field around them and the wall of protection. But there are these opportunities for distribution. And as a recap, your children, if they're appointed as the family trustee, can be given the ability to distribute for the health, education, maintenance, and support. And they would also be referred to as an interested trustee. But if there was ever a need to take distributions above and beyond HEMS, which, as we've mentioned, is relatively rare, they can be given the ability to appoint a distribution trustee or a disinterested trustee who can sign off and authorize those larger distributions if absolutely necessary. Again, with them recognizing and remembering that when they take those big distributions out, they're losing the asset protection that we're trying to provide to them. But there can be occasions where it's just needed, and there's nothing they can do about it, and they have to have it. And if they do, we're building in the flexibility to make that occur.
I think that the kind of takeaway for most adult capable beneficiaries is, like, you're giving them the tools, and it's up to them how they want to use them. It's like you're leading the horse to water. You're not forcing it necessarily to drink, right?
Not that your children are horses or anything like that.
I love horses, so that's a compliment in my opinion. But
common question, and I think important to understand, is the income taxation of these trusts after you've passed away or after they've been created during your lifetime through gifting. Once they're funded, they are separate legal entities, and separate tax returns will be needed to be filed by the trustee each year. And that is not to say that they're causing extra income tax, or that they're income taxable because the money's going in, or that the distributions to the beneficiaries are causing extra income tax. It just means that you have this new legal entity with a tax ID number that presumably will be investing in stocks, bonds, mutual funds, and real estate and business interests. And with all of those different kinds of investments, we're hopefully going to be earning money. And when we earn money, the government, the state, and the federal government are going to want to be paid their fractional share of the income tax. So the trustee will have to file a separate tax return that will aggregate all of the different income being produced by different accounts, because there could be as many accounts as the beneficiary wants. There could be a stock account and a cash account. It could be a business interest, but the business account. So all of those different things, just like we account for those things to our personal tax preparer or accountant, we're going to do the same thing as the trustee of this trust and just give them a breakdown each year. And then the trust accountant will prepare the federal 1041 and then the Pennsylvania 41 if it's a Pennsylvania trust. And then there will be a decision for the beneficiary trustee each year, which is for the income that's being generated by the trust. Should they leave that income in the trust, or should they distribute that income to themselves as the beneficiary? So they are faced with a little bit of a conundrum each year, and they have to decide what's best. And the competing issues typically are that inside of the trust, they get to the highest tax bracket faster. They have a condensed tax bracket system. And if you retain the income inside of the trust, you're playing with the trust tax brackets. So you might end up pushing up faster to that higher marginal rate, and there might be a little bit higher tax paid as a result. Okay. Whereas if you distribute the income to the beneficiary before the end of the year, the trust will issue to the beneficiary a form, which is called a K-1. And a K-1 is very similar to like a 1099 that you get from a bank or a financial institution. It just says you've gotten the distribution of the income from this trust. Now you, the beneficiary, have to report that income on your personal return. So it just gets blended in with the beneficiary's personal income, and then they pay the tax based on their tax rate. So we're not doubling the tax. The beneficiary in that scenario pays the tax and the trust doesn't. So if you distribute the income, the beneficiary pays the tax. If you retain the income in the trust pays the tax. Now the give and take there on the other side is when you give the income out, you lose the asset protection. So you always have to keep that in mind, and the trustee beneficiary will have to decide, do I want to keep it in the trust and maybe pay a little bit more income tax because I need it to be safe? And they'll maybe choose that if they're in the middle of a embroiled fight with somebody, lawsuit or legal action or divorce. And they might say, you know what, I'd rather pay a little bit more tax and keep the income in here as compared to distribute to myself and make it all vulnerable to what's going on. Or they might say, I've got smooth sailing in my personal life. I don't see any problems on the horizon. I'm going to distribute that income to myself, and I'm going to choose to pay maybe a little bit less income tax as a result of distributing the income to myself. So every year, they just have to go through the mechanical process of deciding, do I want to keep the income in the trust or do I want to distribute to myself? Takes, an hour or two every late November, early December with their financial advisor or accountant to make that decision, and they're good to go. So pretty straightforward process once they get up and running and once they understand it. It's the sort of the price of doing business when you've got a goal of asset protection. We're creating a legal entity that's separate from theirs. So naturally, with that, we're going to have some income tax preparation and filing that goes with it.
Thank you, Doug.
All right.
That is something that clients always are curious about. What is the impact in that regard? So we have so far talked about like what is the purpose of these trusts, how are they structured, created, funded. So at the time that you pass away, when they're funded, typically, if it's not that lifetime situation that Doug was describing, and then the administration during the lifetime of your child. Who's in charge? How are they making distributions? What are the distributions for? But then we have this next phase, which is, well, what happens when that beneficiary, when your child passes away? So when a beneficiary of one of these trusts passes away, it's really kind of up to you to decide at the time that we're talking about what makes sense for you and your family, what's going to happen in that circumstance. So there is something under the terms of these trusts, it's called a power of appointment. And a lot of clients who have adult capable beneficiaries say, I want it to be up to my kids. So I want them to have this asset protection during lifetime, but when they pass away, I want them to be able to decide where the assets inside of their trust are going to go. And so they give them a very broad power of appointment that says it's up to them. It can be their spouse, it could be their children, it could be a charitable interest, some combination of all of those, some other relative, friend, loved one. It's entirely their choice. And that's what lots of clients choose. I sometimes have clients who like to be a little bit more restrictive about that. And I'll generally see that in a context where maybe we don't really adore or trust our daughter or our son-in-law, to not, if they were to receive that inheritance, to make sure that it's benefiting our family and our grandchildren. So if that's a concern, it can be drafted to restrict that power of appointment a little bit and say, okay, you're able to say this is where I want these assets to go, but it's going to be limited to a particular group, a class of people, like my descendants, my either your beneficiaries, other siblings, or your grandchildren, etc. So that'll be up to you to decide how restrictive or flexible you want to be there. It's generally will require that that power of appointment is exercised under their testamentary documents. It's again comes back to this. In most cases, we're looking to give as much flexibility as possible to your kids. You want them to be able to control and access the assets in the same way that they would have had you left them to them outright, while still giving that asset protection. I have tons of clients who say to me, well, gosh, Annalise, that's great that they have this power, but what happens if they don't get around to exercising it? What if they just don't ever do it? You tell them that they have this power, you remind them that they should do this, and then they don't do it. We will typically draft to say that the default in that situation is that the assets inside of the trust, if they've never exercised their power of appointment, it goes down to the next generation automatically. So it goes to your grandchildren, it goes to your children's children, and it just keeps going down that family line. And tons of beneficiaries, when I explain that to them, you say, okay, well, it's going to, if you do nothing, it will transfer to your children. They say, well, that's exactly what I would want to happen. And so they don't ultimately exercise that power of appointment because they're very comfortable with the default. So those are most of the circumstances we see. We always provide for contingencies. What if there isn't a next generation? What if something happens, your child's not here, they haven't had children, it goes to maybe their siblings if they're not here. There is no circumstance, the way we draft these trusts, under which the assets are just kind of like floating around in a vacuum and they have nowhere to go. That would not happen. And we'll talk through all of those different options and you make the choice that makes the most sense for you. One of the things we haven't touched on a lot is during this, we've been very focused on like the asset protection during lifetime that this trust planning provides for your children. But there's also this phenomenal potential huge tax savings where when these trusts are funded, because your kids never took possession of those assets, they're in this trust. And we're not going to get too far down into the weeds. It's kind of beyond the scope of what we're doing here today, but it's using up your exemption that you have at this federal level to fund these trusts so that when your children pass away, what is inside of this trust would not be includable in their estates for federal estate tax purposes. And just for even easy round numbers, let's say you leave, $5 million in a trust for your child, that grows to $10 million during their lifetime. They pass away. Instead of that $10 million being includable in their estate, it's not there. It's not part of their estate. And that could equate to a huge savings because that federal estate tax is a 40% tax. So right now we have exemptions that are approximately for this year about $14 million per person, but there is absolutely no guarantee that we're going to stay in this high exemption environment. The recent bill that passed upped that to $15 million per person. It says that the exemption is permanent, but we all know that that does not mean that it is actually permanent. Any change in Congress, we could see a significant decrease in that exemption. So this can be a phenomenal benefit. If that $10 million is inside of this trust that you created for your kids, they have $10 million of their own individually held assets. That exemption that's almost $14 million now comes down to 10 million. That's a scenario where, because you did this trust planning, that $10 million in the trust is not subject to that 40% tax. Had you not done the trust planning, that $10 million would put them $10 million over that exemption in our hypothetical, and there would be a 40% tax on that $10 million. So it's this really powerful tool for future benefit to the next generation as well. It's not just that lifetime asset protection. I will point out, though, sometimes when we discuss that, people say, well, wait a minute, what if we're not concerned about that exemption? Do we get the step up in basis? Would my kids get that? Would my grandchildren get that benefit at the time that my child passes away? And the answer is it can be triggered if that is the result that we want. And so we draft the trust and take that into consideration and say, in a circumstance where it makes sense for assets to be included in the estate, they can be. So I would preemptively respond to that question. It's one that we get frequently. So we've talked trust funding, the purpose of the trust, what's happening during beneficiary's lifetime, who has power to do what happens when beneficiaries pass away. We're going to talk now just about some of the key points and considerations, a little bit of a recap. And I'm going to actually, we have this divorce protection first. I'm actually going to talk about the importance of beneficiary designations first. I think this is really, really crucial to discuss. This topic is something I don't like to say necessarily like we harass our clients about it. That has a negative connotation, but we are constantly reminding clients how important updating beneficiary designations are to make sure that they coordinate with this trust planning. As Doug said, majority of our clients are doing this kind of planning, and you can create this planning, tailor all of the terms to the trust to be just absolutely perfect, accomplish all of your goals, be just like this excellent fit for your family. But if you have large investment accounts that you have not updated the beneficiary designations to say that I want these assets to go to this trust when I pass away, you have now subverted the purpose of this planning. So if there is an account, a brokerage account, a retirement account that says spouse is primary beneficiary, contingent is to my kids outright, if those accounts go outright to your children, they cannot take those assets and put them into this trust that you have created for them. You have to direct those accounts to that trust. We will help you with that. We give you the language to do that. And so we give you the language. You can work with your advisors, make sure that those designations get updated so that the full benefit of this planning can be realized. I always like to point out when I'm talking about beneficiary designations, tons of people have a large percentage of their overall net worth in retirement accounts, IRAs, 401ks. These trusts, we draft them to be optimized to hold those kinds of accounts. There is a law called the Secure Act, really changed significantly the way that inherited retirement accounts are dealt with, the rules surrounding them, distribution periods, et cetera. We consider absolutely all of that, and these trusts are optimized to hold those kinds of accounts and give your kids the flexibility that they really need to be able to make decisions related to distributions from those kinds of accounts and the rules that apply to them. Back to divorce protection. I just think that the beneficiary designation portion is really crucial and important. I like to highlight that and really reinforce the interaction between those things. We talked about family meetings. We also like to take a really team-based approach, I think, with advisors as well, and being able to assist and make sure that what's happening in the financial planning piece coordinates really well with the estate planning piece.
Yeah, it's tough because we know how important those beneficiary designations are. And we do harp on it in our discussions and all the literature and the paperwork as we're working together with a client. But once we hand that beneficiary designation language or the suggested language to you or a client, it's up to the client to then take that language and make sure that it gets implemented with their financial advisor or financial institution that they're dealing with. And we can't do that. We're not doing that piece of the actual submission to the financial institution. So we can tell you that this needs to be done, and we can tell you what the language should be, but then it will be your responsibility to take that and do it yourself above and beyond creating the documents. So step one is to create the documents. Step two is for you to take the language we give you, implement the beneficiary designation to reference the trust planning. And it's probably worthwhile. I don't think that you had just mentioned it, so I'll just take the second. And the way the beneficiary designation would frequently look is that it would say my spouse is my primary beneficiary, but the contingent beneficiary after my spouse has passed, or if my spouse has predeceased me, I should say, is, let's say you have 2 children, 50% to the trust under my will for the benefit of my daughter, 50% to the trust under my will for the benefit of my son. And that way, if you were to pass away, that account pours into those 2 trusts and doesn't go to your children as individuals. So the important part is that you're naming the trusts for the beneficiaries and not the beneficiaries themselves.
That's really important. And to Doug's point, that's your final homework assignment. That's how I always kind of categorize it. You have this one big final homework assignment, which is to make sure that those beneficiary designations get updated. All of the different financial institutions have different rules and forms, and there's no way that we would be able to kind of keep track of all of that and have a library. So final sort of thoughts, summarization, considerations. We've talked a lot about the divorce protection, and we keep talking about it because it is such a driving force and such an important goal for a lot of clients. Just to anything that you leave outright to a child, anything that they're titling jointly with a spouse, that's going to be a marital asset. That is going to have that vulnerability. When you do this trust planning, those assets are not part of the marital estate. It is one of the huge benefits to this trust planning. We just talked about this. Your children cannot put assets into these trusts later. Any assets that you have left to them outright or any of their own individually held assets, the structuring and implementation of the planning has to happen for your assets now while you're doing the planning. It's not something that the kids are going to be able to kind of respond to or undo or fix later on. And so it's something that has to be dealt with now. Let's see, there is this concept of a self-settled trust. And so this asset protection planning that you are creating for them is just such a phenomenal gift that you can give to them. You are creating a situation for them that they could never create for themselves. And so you're leaving these assets to them in an environment, in this protected bubble, behind this force field, while they still are then going to be the trustee. They're still going to be in charge. They're going to have all of this access and this control. If you left assets to them outright, it's not something, certainly in Pennsylvania, that they would be able to create for themselves. They couldn't take these assets in Pennsylvania, put them into this trust of which they're the trustee, they're the beneficiary. They are in control in the way that you are allowed to create that for them. You're a third party funding this trust for their benefit. Because of that, they get this awesome asset protection. It would be considered a self-settled trust if they were to try to create that structure for themselves. And it's just something that doesn't give them all of those benefits here in Pennsylvania. So it's a really, really phenomenal gift that you can provide for children, for other beneficiaries. And we're talking in the context of children. You can create this trust planning for nieces and nephews, other loved ones. It's most frequently for children, but it is available in other family structures as well. Final thoughts. You have worked long and hard to build wealth, create this financial legacy for your loved ones. And I think it's something that we can all agree on. We would never want that inheritance to be lost to one of these. I like the expression creditors or predators. I always think that's a good one.
Yeah.
To creditors, predators, divorcing spouse, lawsuit, whatever it might be, the thought of our kids losing their inheritance, our loved ones losing their inheritance is just hideous. We hate it. We don't want that to happen. And the good news is that you have the ability to structure your planning to give them that protection so that they don't have that situation and that circumstance. We've talked, I think, touched on kind of lightly, briefly, this concept of multi-generational interaction, family meetings and such. But this is not something that only you can implement for your children. You can talk to also your parents and see if they can implement this planning for you. And that way we're starting up at sort of that top level, at that next generation, and creating this legacy that's transferring from grandparents to children to grandchildren to great-grandchildren, and just keep go down that family line, give that lifetime asset protection and potentially that really huge future estate tax savings benefit as well. Anything to add, Doug?
Yeah, I think this has been great. We appreciate you taking the time to watch and to listen and to get a little better understanding about the opportunities that we can provide on the planning side, and the things that you can do to make things even better for the next generation as you leave assets to them.
Okay, I have a slide here, has our contact information. If you want to implement this planning, call us. Call this number right here, the office number, and we'll get scheduled we have a wonderful team of support staff, really great group, and they'll be able to get you all sorted, get you scheduled to meet with us. We have a ton of great resources as well. Anything on our websites, the links are here. We are going to make these slides available to you. So you'll have all of this information. We'll get that sent over to you along with a copy of that report that we were talking about that describes this planning that you may want to share with beneficiaries, trustees, etc. So thank you
Yep.
so much for joining us. It's really been a pleasure. Reach out to us anytime.
Thank you.
Thanks so much.